In India, day in and day out, we have been hearing crimes in live-in relations. Live-in relationships and presumption of marriage gains lot of weightage. That's where this is going to be the central point of our today's discussion. In India, courts have repeatedly held that long-term living together can raise a presumption of marriage. It is common for courts to raise this presumption in order to protect the interests of the parties, most particularly women, to such arrangements and their children. The Supreme Court upheld the legal validity of a 50-year live-in relationship in the case of Tulsa and others versus Durghatiya and others, 2008 for SCC 520. Generally, the court presumes the existence of any fact that it believes is likely to have occurred. It is clear from reading section 50 and 114 of the Evidence Act together that the common course of natural events and the conduct of parties can be presumed to be constituting a marriage where partners have lived together as husband and wife for a long time. A strong presumption arises in favor of wedlock. In spite of the fact that the presumption can be rebutted, those who wish to invalidate the legal basis of the relationship must bear a heavy burden. Legitimacy is favored by law, while bastardy is frowned upon. According to the Supreme Court, in Madan Mohan Singh versus Rajnikant 2010-9 SCC 209, a long-term live-in relationship cannot be viewed as a walk-in and walk-out relationship, and there is a presumption of marriage to it. Clearly, the court believes that long-term live-in relationships should be treated as marriage rather than as a new concept like live-in relationships based on its approach. To determine which relationships are in the nature of marriage, the Supreme Court provided certain guidelines which are as follows. First and foremost, a reasonable period of time to maintain and continue a relationship is defined as at any point of time in Section 2F of DV Act, which may vary from case to case depending on the facts. The second point is, as defined in Section 2S of DV Act, the term shared household does not require any explanation in the sense that partners must be living in a shared household for them to be presumed as live-in partners and thus as a marriage wedlock between them for a substantial period of time. Okay. Third, financial arrangements and resources pooling, supporting each other financially, sharing bank accounts, acquiring immovable property in joint names or in the name of the woman, investing in business, having shares both in separate and joint names so that a long-term relationship can be established, which may be a guiding factor. In fact, the logic that one needs to gain from here is a one-night stand or a purchase of sex from a woman for 7 days, for 30 days kind of period does not give rise to any kind of live-in relations. That is to say, there is a consideration for the said act between the partners and the consideration fulfill the obligations, hence there is no relation. But if two people have financial arrangements and resources pooling, supporting each other so that a long-term relationship can be established, which may be a guiding factor. So one needs to remember that a prostitute or a person who sells sex cannot become a live-in partner and cannot claim as a live-in partner. But here, to be eligible to be a live-in partner and thus to claim herself as a part of wedlock, the subject needs to bear in mind the kind of arrangements like the joint arrangements the subject needs to have with his or her partner. When we come to the fourth point, it's an indication of a marriage relationship when the woman is responsible for running the home, cleaning, cooking, maintaining, or upholding the house, etc. The fifth point is marriage is a sexual relationship not only for pleasure but also for emotional and intimate relationships, for procreation, for providing emotional support and companionship, as well as material affection and caring. Number 6. there is a strong correlation between having children and a marriage relationship. It is therefore intended that the parties will have a long term relationship, a shared responsibility for their upbringing, and support of children is also a strong indication of live in relationship and marriage. Seventh point, taking the relationship out to the public and socializing with friends, relatives, and others also gives a presumption that they are married, and such kind of acts brings into the forefront one of the strong factors in maintaining the relationship. Last but not the least, the eighth point is the nature of relationship is determined primarily by the parties' intentions and conduct regarding what their relationship will be and include, as well as their respective roles and responsibilities. While live-in relationships are socially unacceptable in country like India, they are neither crimes nor sins, and they are personal choices whether to marry or not to marry, or whether to have heterosexual relationship, as it was the woman who invariably suffers due to the breakdown of such relationships. The apex court bench also cited examples of countries that had recognized such relations. However, the courts in India have taken pragmatic approach with reference to live-in relations, and for the victim, when proved that such relation existed, courts have granted the status of marriage to such live-in relations. And the question is who the victim is and what circumstances led to that kind of victimization of the particular subject. Even though live-in relationship is recognized by the judiciary, it is still a taboo in our society. But for true victims, there are always the courts which can come to their rescue as and when there is a presumption or assumption that a subject of the partnership is victimized by another partner, then such affected subjects can always approach courts for justice and maintenance and also all the benefits of a legitimate marriage for long term live in relations. Hope the information is useful. Thank you very much for your patient hearing.